You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. We are joined again this week by attorney Terry Finkelstein to continue our discussion talking about estate planning. Terry, welcome back to our show. Nice to see you this Sunday morning.
Thank you. It's good to be back.
Yes. So last show was quite informative. We spoke about wills and living trusts, the difference between the two, what should be in the basic will. So we're going to continue our discussion about estate planning. But before we get started, please give us tell us an overview of your firm and your contact info.
Thank you. I'm a solo practitioner attorney. I provide a wide set of services, including estate work when people pass away, wills, living wills, durable powers of attorney, expungements, which involve erasing prior violations or even arrests, divorces and child custody arrangements, and municipal court cases involving traffic tickets. I'm the only attorney in my practice, so you know who you will be dealing with. You will not be given to a new, inexperienced attorney or paralegal.
Mm-hmm. And your phone number?
732-254-1300, 732-254-1300.
Okay, great. So let's continue with last week's show. Let's follow up. We spoke about what the components that should be in a will and about how you can designate for the loved ones, the passing to the children and, to the grandchildren and, the reasons you may have to modify a will due to life-changing events, the unfortunate death of somebody who's a beneficiary or the addition of new family members, new grandchildren, et cetera. Let's talk a little bit, without getting too crazy with the tax implications, about the beneficiaries. We covered last show that the estate tax is way out there at like $13.5 million, so that's not really an issue. But what about inheritance tax in terms of passing to different, Class A beneficiaries? And, I know husband and wife, they'll have no inheritance tax issues. But what if the assets are passing from the parent to the child or to the grandchildren, which is common in wills? Are there any potential inheritance tax implications?
Again, the $13.61 million is federal tax, so normally that's not a concern. Inheritance tax for the state of New Jersey, though, is a concern, unless you leave everything to your spouse, children, or parents. Those are all referred to as Class A beneficiaries, and basically everything passes tax-free up to a certain amount. You have Class C beneficiaries. For some reason, there's no Class B.
Right. That's I know.
Why is no Class B?
You have to ask the legislatures, whoever. Maybe they wanted to reserve it for some future class.
I don't know. But the Class C beneficiaries are brothers and sisters, and they get the first $25,000 that they're left off the top, and then it's 11% up to $1,075,000. So what people don't realize, when you leave it to brothers and sisters, there is a tax.
Right.
But the tax is paid on by the residuary portion of the estate. It's not paid by the recipient, which is kind of interesting. People think that the beneficiary, the brother or sister, has to pay the tax out of their portion. And unless in the will specifically the testator says that I want to pay it out of his or her portion as the brother or sister, it gets paid from the residuary clause.
Interesting.
In addition, nieces, nephews, aunts, uncles, friends, non-relatives, everything there gets taxed at 15% up to $700,000. And over $700,000, it's 16% and actually goes up a little more after that. Charitable institutions, if you leave something to the Cancer Foundation or ALS, then that is also tax-free.
Okay.
This is what the Elisi Masonry institutions use in order to get you to contribute, because there is no tax. So you do that.
Sure.
It's very, very interesting. You can leave your estate to whoever you want.
Sure.
And it's very, very interesting that you can leave things to dogs, cats, and hamsters if you
Yes,
wish.
that's what I wanted to talk about this show, too, before we talk about the power of attorney and the living will and the other aspects that should be in an estate plan, which you prepare. Let's say somebody has a pet, an elderly couple, the husband and wife, they both die, but they have maybe a dog that's in the midlife, maybe 3-4 years old, or even a puppy for whatever reason. They think they're going to live for another 20 years, and unfortunately, the couple deceases. They can leave. How would it be? They can set up like a pet trust or somehow provision so that money's set aside for the care of the pet, and then how would that all work?
It's very interesting.
Yep.
I've had two in the past few months where people had cats. And in the will, we had a person who was going to take care of the cats and a backup person in case that person either did not want to or was unable to.
I see.
And then we left a certain amount of money for food and veterinary care.
Wow.
Yeah. Now, with that money, not to get crazy, because again, this is just general advice. It's not tax or estate planning. If you need specific advice, you have to contact Terry. But in that situation, if there's let's say $30,000 allocated for the care of a cat, and that's given to, let's say Jane is the primary caretaker, if she has that money, is the estate taxed on that bequest if she's not a Class A beneficiary per se, but she's just a caretaker or non-blood related? That gets complicated, I guess.
It does, and normally you would get taxed in that situation.
Really?
But I had another case where a client has for years taken care of about 30, 40 cats. He lives adjacent to a park, and he actually feeds. I mean, he buys food in bulk from Sam's, and he feeds the cats, which some of his neighbors appreciate.
And some
Others
don't.
are not so pleased with it. So you got loads of feral cats running around.
Yeah.
But in this case, though, he designated a tax-free institution to take care of the cats and continue feeding them. And he left over $1 million.
Oh, my God.
Oh, so that the really just a cat lover wants to see just the general welfare of all the feral cats out there.
That is correct. And the charitable organization, God forbid the cats dry up, gets to keep the money.
Yeah, and maybe they have something specified that if in that case, then the charitable organization would have the obligation to use it for the animal welfare benefit, or as their intent. So. Oh, that's really interesting. Yeah. So the trick, I guess, not the trick, but the idea is set up the beneficiary or the caretaker as a charitable institution to avoid the estate being taxed on the bequest.
Exactly.
Yeah, that is really, really.
I had a client, right? Unfortunately, they were together for 20 plus years. They never married because they both married before. But husband, the guy who passed away, does not have children. So, but she has. So they never, they've been together for 20 years. They never married, but because they didn't think there's a need for it. And when he suddenly passed away of a heart attack, because he has a will, he has a will. Everything he said go to my wife.
And New Jersey doesn't recognize unless I'm mistaken, they don't it's unlike New York. New Jersey does not recognize common law marriage. You either have to be married or you're.
Yeah, he said everything go to my wife, but they're not formally married. So the poor lady have to pay a huge amount of tax because she was not related to him. Otherwise, except the relationship. So
right.
that was that's
right. There's no blood relation,
and then the nephew of the guy, because he has no children, and his ex-wife passed away before that. He has no children. His nephew challenged her in court for the will because he left nothing else, just leave to her. So that was like a really sad thing, Yeah.
Yes, you would try to challenge that and hopefully work out a compromise.
Yeah,
but you'd have great difficulty in that situation.
And since this show is about wills and estate planning, let's talk about that. Even though it wasn't on one of our pre-planned topics, it's the wills can be challenged for different reasons. I'm going back to my law school days. Duress, stress. Different. We could talk about the reasons that people may decide they want to challenge somebody's will. It happens with family members. Unfortunately, there's arguments.
Yeah, normally it's either mental capacity or undue duress.
Yeah.
And usually the person's in a nursing home or a hospital. And that's why I'm kind of reticent about going to hospitals and nursing homes. And I make sure that the person is really, really with it, that they actually know what they're doing. If they don't, I refuse to do their will. And used to be you could get the witnesses at the hospitals or the nursing homes without any problems at all. Now they refuse. It's like they've been given orders not to sign, then they get dragged into court.
That often we've experienced that also with libraries and banks
Yes.
and things. It used to be you could get notaries done there, but now they have certain policies, like you mentioned, where they specifically ask what they're notarizing, and if it's a legal document like a will, they might just say bow out and just say you can't do it. So that's why it all goes back to having the attorney do it, and the witnesses. And that's another thing too. We can talk about a will has to have two disinterested witnesses. Can you explain how the witnesses, their relation with the testator, the one making the will?
Yes, basically, the witnesses are secretaries in my office or secretaries next door, doctor's office, and they don't need to know the person. They just need to know that the person is signing voluntarily. I always check and get a copy of the driver's license from the person who is signing the will. But the witness just needs to make sure that the person is signing voluntarily and that they know that what they're signing is a will, not under the influence of drugs, alcohol, no one holding a gun to their head to do that.
Yeah.
Can you have if I'm signing a will, can I have my brother or sister as a witness? Can you have a blood relative? The answer is no, right?
You shouldn't.
You shouldn't, right? Otherwise, you're opening up for
Yes.
trouble.
Exactly.
Unless you are not part of the will. Maybe, if you get nothing. If I get
You should
nothing.
try to avoid it if possible,
Yeah.
but if you're not part of the will, it's much, much cleaner.
Yeah, because I have nothing to do
And
with it.
definitely a beneficiary can never ever be a witness to a will. Otherwise, you could contest the whole validity of
You can contest it, but usually, if you have no one else, you got to do what you got to do. So
Oh, okay.
You know what?
if no
The
one
key.
contests it, you're fine.
Yeah, the
Yeah,
key
that's
thing
true.
is
Yeah.
be prepared, do it early. Secondly, go for professional advice,
Yes,
professional
that
office
goes back to having
to
that's to
avoid a
call
lot of
Terry and have
issues.
an
Yeah.
attorney do it.
That's right.
All right, why don't we take a short break? We'll be right back after these messages. Okay, welcome back to our show. So we're going to continue our discussion with Terry Finkelstein, an attorney. We're going to now switch the focus to talking about a durable power of attorney, which is all part of the estate planning. And Terry, to start with, please explain what is a durable POA, power of attorney, mean?
A durable power of attorney is kind of a lengthy document, and it's used primarily for medical care for an individual. If an individual is going to go into a hospital or has medical problems, normally I have them sign a durable power of attorney. It does not have to be witnessed. It's just notarized by me and is witnessed by me as attorney. And the durable power of attorney basically provides that medical decisions can be made by the power of attorney. So the person designates a spouse, a child, a good friend to make the medical decisions. And we also provide that, God forbid, that person is not available or doesn't want to or moves out of town, that there's a backup who can exercise that authority. But hopefully it won't be needed, but sometimes it is. It also provides for taking money out of the bank, cashing in bonds, stocks, you name it, for the person. But there is a minor problem with using a power of attorney because the person who you designate has the power immediately unless you provide that it's not going to be valid until the future.
Right. How about for signing a deed or a deed for the house? Let's say the house is under contract and they're ready to close on it, and then somebody comes and says, "Well, unfortunately the homeowner had to go to the hospital. They're going to be in the hospital. They're going to be bedridden for the next week. The closing is supposed to occur," and they try to use the durable power of attorney. Usually, I think title companies may give it depends how, I guess, the language on that.
Yes, exactly. Normally, I don't like using the durable power of attorney for that. I have a separate straight power of attorney
Right.
that allows the person to remove money from bank accounts, trade in stocks, and sell or buy real property. And
Right.
it's just one page, and it's very, very, very specific, and it gives the address of the property.
Right.
Oh,
right.
yeah.
And usually that would be needed to muster the approval of probably the title company that the buyer's using to make sure that that person, given the durable power of attorney, really has the specific authority to sign off the deed for the real property.
Yes.
Yes,
Yeah.
I don't like powers of attorney to transfer real property
Yeah.
in any case.
Sure.
But that's one where you have no choice. And we're
Sure.
very, very careful.
So if somebody comes to you for an estate planning to do a will, you would recommend to the client, and again, this is not specific legal advice, but it's generally a good idea. Besides having the will or living trust, that you would also recommend they prepare possibly a durable power of attorney to have at their disposal and if needed.
If they're not well, if they anticipate they're going to be in a hospital or a nursing home. But we've had a number of occasions, unfortunately, where the holder of the power of attorney actually cleans out the person who is making the power of attorney, and they take their money.
Oh,
and
my
it's
God.
horrible.
And then it gets into litigation and then really costly.
Exactly.
And that's wow.
Okay, so you have to be very, very careful who you're designating your power of attorney. It has to be someone, if it's a spouse, even children sometimes. Nothing's worse than a child taking money from a parent.
Yeah, and since we're talking about estate planning, oftentimes an elderly parent may want to update their bank accounts to have a child or their children as as account holders, which can be good in some cases, practical, but also it could be subject to risk for getting your bank account cleared out if the children's intentions aren't the best. So the same.
Well, when people come in to do their will, frequently they come in with a child who's egging them on, and the child also wants a power of attorney. And normally I say no, that it's not necessary.
Right. And oftentimes, I think I heard when you do wills I think you probably do it the same. It's good to have the consultation, a one-on-one with the testator, the person writing the will. It's not a good idea to have children hovering there because they may feel undue duress or pressure from their kids to make certain requests, right? So you probably recommend to your clients that you prefer they come in just themselves for a one-on-one consultation.
Well, I ask them. Frequently, the child comes in anyway.
Yeah.
They don't listen. And when the child comes in, I ask the older individual whether or not you want that person out of the office and want to talk to me
private.
without the person here. And, the person looks at the child and, what can they say? They say, no, it's okay. He can stay or she can stay.
Sure.
Unfortunately, right?
Yeah.
Sometimes, yeah.
Absolutely. So that covers the durable power of attorney. Let's talk now about another very important document, the living will, and what is a living will?
Living will, at least as far as I'm concerned, is a one-page document, and it gives a person the right, basically, to pull the plug, to be very crass on an individual, so that if you're essentially brain dead, you're hooked up to machines, and it's just keeping you alive, keeping the heart pumping, and it serves no purpose that your son or your wife or a good friend can say, enough is enough, I don't want the person to go through the agony. But again, here there are other problems, because I sometimes go to the hospital, I see this person, and there's a living will, and the child has the authority to pull the plug, and the person is not really conscious, but I hold the person's hand and he's able to squeeze it, which indicates at least some of the some of him is going forward, and he may not be brain dead. And I say, maybe you shouldn't pull the plug.
But
and the children want to pull the plug to get the money.
But sorry to interrupt you, but wouldn't the doctors, the medical doctors, then verify that there is still some brain activity before they would even allow the child to pull the plug? I would think there would be like the attending physicians would have a say where they're not just going to allow the child to pull the plug unless they But unless, I don't know.
But a lot of time is the personal choice, right? Like my father died of cancer, as you know, right? Many years ago, suffered 3.5 years because we tried the daughter, I tried everything we could. And I even threatened the hospital, if you not doing your best, I'm going to go after you, right? But my mom saw all this. So my mother told the doctor and the caretaker she doesn't want to do that. And they especially had a document to sign. She's in there. She said, well, don't save me unless you can cure the sickness. And the doctor have to quantify by how long, by what. And then she want to sign that document. They have to make me flew there to sit there. So in the future, I can't accusing anyone. So they made me, my mother said, oh, my son's okay, my daughter is a problem. So make sure she come here. So I have to sit there to witness. They had a translator, they had everything. My mother said, do not save me. I don't want just.
But Terry's point is a little bit different. His point is that there's still if somebody can squeeze your hand, that means the brain is still, they can touch, they can feel, they have some cognition that of other human beings around. And in that case, this is a case where the child may be in a rush for whatever.
Yeah, the child wants,
I
understand.
You don't know what the
intentions
intentions of the child.
Yeah.
Maybe the child feels, well, they're still suffering and they want to end it, or they want to end it because they want to end it and they want to get to the
estate.
You don't know. That's a very, very interesting point. I never heard that angle before, but that happens. It's interesting to hear that happens.
It does, and it can be an involuntary reaction, and it may not be actually the person doing it intentionally, but you don't know.
Yeah.
Yes, I agree.
That's the case, and the doctor, a primary doctor, normally comes in the morning for 5 or 10 minutes, and you've got interns the rest of the day, and you don't necessarily have someone who's going to say, don't pull the plug, they need the bed, they need more room in the hospital, and they're not adverse to doing it at all.
Now people may be rethinking, everybody out there with the living will may be rethinking the living will a little bit.
I think it's really, like you said, it depends on the person's intention, right? Whether whoever had the power, whether they act out on your intention. You know, for me, I mean, if that's the case, I'd rather go. So I'm worried. My husband has the power. Whether he would say yes, just pull the plug. He probably say, "Well, I'm not gonna pull it. I'm not gonna." But that's against my will, right? Yeah. You know, I don't want to be here unless I can talk, right? Yeah. So that's really depends. I mean, exactly as you mentioned, is the tension. You know, I've that person who had the power of attorney. You do it because you end the suffering, or you did it because your personal gain. That's the question.
Good question. Yeah.
The example you always use, if someone's in a coma and not coming out, and then they come up with a cure for cancer or cure for this or that, in the next moment, and they can cure you. And you pulled the plug already. Somebody wake up 10, 20 years later and from the coma, and then they talk about, they ask the person who's the present to give the present 10 years ago. So the person's alert, but they just slept 10 years. So,
yeah. So it's really a difficult choice because you don't have all the medical. Nobody has all the data and knows the welfare of that person or what their extent of their interior decline is, and if they're going to come out of a coma, it's not predictable. So
but think carefully before you send out power of attorney.
I mean, you mean the living will?
Living will.
But I think it's still a good idea
living
to have
will.
a living will, and most you just have to trust that the loved ones behind you will make the right.
And also speak to the professionals like Terry. At least they can ask the questions, prompt you to think more rather than just sign it. You know, you have to think more than that.
Right. Now, the listeners, our last show, we're going to change the topic a little bit. We're going to focus more on the real estate. The question we had from the last show was, which often comes up, is what if a husband and wife have a deed, the husband passes away, the wife was never on the deed for 123 Main Street, anywhere, or East Brunswick, USA, New Jersey. What happens if if the surviving spouse was never on the deed for the property for 123 Main Street? Does the existing deed have to be modified, or will she be able to sign the title without making any modifications?
Was the house the principal residence?
The house was the principal residence, principal marital residence for like 2 of the last 5 years, let's say. Yeah.
She will have to sign as the executor
Right.
and also as owner because it was a principal marital residence.
Right.
New Jersey is very, very screwy that way. If you live in a house as husband and wife and one of the spouses is not on the deed, that person over the years obtains an interest in the property and must sign the deed when it's transferred.
So she'll have to sign in two places. She'll have to sign she'll have to sign her name as her normal name. Then she'll have to sign for the deceased husband as she'll have to sign his name as the executrix of, or is the surviving spouse for the, John Smith, if that's the
If it's
deceased.
husband and wife.
Husband and wife, yeah.
But normally it wouldn't be because she's not on the deed.
Right. So it's, yeah, but the bottom line is she can proceed for the closing. She doesn't need a special deed prepared before she can. It would just be all done at the closing table.
Correct.
With the
Yeah, I often had a question if the husband and wife name both on the deed and one passed away, and whether they should change the deed. And so, as you said, no, there's no need. They can sign the listing agreement, they can sell the house, and the lawyers and the buyer title company make sure everything will be done properly at the closing.
That is correct.
That will save the money and time. Yeah.
Great. So we're out of time, but thank you so much, Terry, for appearing again on our show. And one last time, please give our listeners your phone number so they can get in touch with you.
It's Terry Finkelstein, 732-254-1300. Thank you for having me, Ken and Jane.
It was our pleasure. Thank you so much.
If you don't have a will, please call Terry.
Yes. Second that.
Yeah,
right.
Okay.
Enjoy the rest of your weekend.
In favor.
Yes.
Bye.
Bye. Bye now.
Bye.
Thank you.